All right, let's dive right into this explainer. Today, we're unpacking a genuinely fascinating legal puzzle about a finalized constitutional ruling and asking a pretty wild question. Can the highest court in the land just go back in time and fix a supposed mistake? We are looking at the 2001 South African Constitutional Court judgment in the case of Moise versus Transitional Local Council of Greater Germiston. At the heart of this case is a concept that honestly sounds a bit more like science fiction than constitutional law, but it has massive, real-world implications for how justice is actually served.
To solve this puzzle, we really have to start with a profound question about what actually happens in time when a law is declared unconstitutional. Think about it. Does the law just poof, vanish the day the judge bangs the gavel, or is it erased from the history books entirely, like it never legally existed at all? The answer isn't as straightforward as you might think, and it completely rewrites the legal reality for anyone whose rights were affected by that bad law in the past.
So, here is our roadmap for unpacking this whole constitutional time travel situation. We'll be covering 6 parts. First, a request to reopen. Second, the rule of finality. Third, was there an oversight? Fourth, the objective theory of invalidation. Fifth, the 1994 versus 1996 constitutions. And finally, number 6, the final verdict.
Moving into Section 1, a request to reopen. Let's look at the exact event that triggered this entire legal investigation.
Picture this. It's July 4th, 2001. The South African Constitutional Court confirms a High Court order striking down a specific section of a 1970 law. Now, this old law, the Limitation of Legal Proceedings Act, placed some really severe procedural restrictions on people who were just trying to sue provincial and local authorities. The court rightfully ruled this was unconstitutional. But almost immediately after this victory, a non-governmental organization called the Women's Legal Center stepped in as a friend of the court, or amicus curiae. They pointed at these critical dates in South Africa's constitutional history and raised a massive red flag.
What's really interesting here is the argument they made. The Women's Legal Center claimed the court had made a patent error or omission. They argued the judges should have added a specific provision making the invalidation retrospective to April 27, 1994. That's the exact date the interim constitution came into force. By staying totally silent on the timeline, the amicus claimed the court created this massive cloud of uncertainty for any ongoing legal actions that weren't already time-barred by 1994. So they essentially asked the court to reopen the judgment and fix this perceived mistake.
Which brings us to Section 2, the rule of finality. Because asking a court to just change its mind, that hits a massive structural barrier in our justice system.
Under the common law principle famously established in the Firestone case, courts generally cannot just reopen concluded cases. The central rule here is absolute. Once a court has duly pronounced a final judgment or order, it has absolutely no authority to correct, alter, or supplement it itself. And if you think about why this matters, it makes total sense. If judgments could be constantly tweaked and reopened, we'd literally never have legal certainty. Once that gavel falls, it stays down. For sure!
But, it's the law, so of course there are narrow exceptions to this rule of finality. The Firestone judgment outlines a few, but 2 are directly relevant for us today. First, a court can step back in if it inadvertently overlooked accessory matters, like, say, forgetting to award legal costs or calculate interest. Second, they can intervene if the meaning of the order is genuinely obscure, ambiguous, or uncertain. But even then, that's only to clarify what it originally meant, not to change the fundamental ruling. The amicus basically tried to use both of these exceptions to get the 2001 Moise's order changed.
So, let's look at Section 3. Was there an oversight? We have to ask, did the Constitutional Court actually mess up and forget to mention the 1994 interim constitution?
Well, the amicus argued that the court's silence on the timeline created a genuine ambiguity, leaving room for 3 totally different interpretations. 1, maybe the ruling only operated prospectively, meaning just from the date of the judgment onward. 2, if it was retrospective, maybe it only went back to February 4, 1997, when the final constitution took effect. Or 3, maybe it was meant to go all the way back to April 27, 1994, under the interim constitution. They felt this uncertainty was a huge problem that demanded the court's intervention.
But Judge Kriegler, writing for a unanimous court, shut this down pretty quickly. He clarified there was absolutely no oversight. You see, the plaintiff's original cause of action in the Moise case actually arose in 1998. Because of that specific timeline, the constitutional challenge was strictly and intentionally based on Section 34 of the 1996 Constitution, which guarantees the right to a fair public hearing. The 1994 interim constitution literally never entered the chat. It wasn't raised in the lower courts, it wasn't argued by the government, and it wasn't part of the high court's ruling. So leaving it out wasn't an omission at all, it was completely intentional. Moving on to Section 4, Objective Theory of Invalidity. This brings us to the climax of our legal puzzle. To really understand what happened when the court struck down that 1970 law, we have to look at what the court called the principle or doctrine of objective invalidity. This was a concept first discussed in a case called Ferreira versus Levin, and it is the absolute key to understanding our time-traveling court order. Think of this literally like legal time travel. When a court declares a pre-existing law invalid because it clashes with the Constitution, the court isn't creating that invalidity on the day of the judgment. No, they're simply proclaiming a fact that already existed. If a law is unconstitutional, it's considered a total nullity from the exact moment the Constitution's norms were superimposed onto the legal system. It doesn't just die today, legally it died the second the Constitution came to life.
All right, Section 5, 1994 versus 1996 constitutions. This is where things get really interesting.
The crucial point here is figuring out which constitution's default rules apply to this automatic nullity. South Africa had two different constitutions in the 1990s, and the contrast in how they handle this is brilliant. Under the 1994 interim constitution, if the court struck down a law and said nothing else, the invalidation was prospective only by default, moving forward only. To go backward, they had to explicitly order it. But the 1996 constitution flipped this entirely. Under the 1996 framework, invalidation is automatically fully retrospective unless the court explicitly steps in to limit it. So let's connect the dots. The Moise case was decided strictly under the 1996 Constitution, right? When the Constitutional Court confirmed the 1970 law was invalid, they chose to remain completely silent on limiting the retrospective effect. By saying nothing, the default rule of the 1996 Constitution just naturally kicked in. The 1970 law was automatically rendered a nullity dating back to February 4, 1997, the exact day the 1996 Constitution came into force. There was no ambiguity, there was no mistake to fix. The order meant exactly what it said, or, well, exactly what it didn't say. Finally, Section 6, the final verdict. Let's wrap up this explainer. Concluding that the original order meant exactly what it intended, Judge Kriegler and the unanimous Constitutional Court officially refused the application to reopen the case. As the judge noted, the order designedly and unequivocally operates retrospectively to February 4, 1997. The rule of finality stood firm. The court couldn't and wouldn't rewrite a flawless judgment just because an outside party wished they had analyzed a different, older constitution. But this whole thing leaves us with a pretty provocative final thought about the real-world ripple effects of objective invalidity. We now know that an unconstitutional law is legally erased from the moment the Constitution takes effect. But what happens to all the people who were denied justice under that bad law during the years before the court finally struck it down? If an unconstitutional law legally never existed, how on earth do we handle the chaos of the past? It's one of those questions that really forces us to realize that even in the highest courts, fixing history is never quite as simple as just turning back the clock.